much.
Thank you very much, Honorable House Chair.
Honorable members, that concludes party responses to the statement. The next item on the order paper is a motion in the name of the Honorable Mr. J.S. Malema. I now recognize the Honorable Malema. Is the Honorable Malema?
Chair, can you hear me?
I can hear you, Honorable Member. You may proceed.
Oh, thank you very much, Chairperson, and members of the House. The Parliament of South Africa, since the dawn of democracy, has had many speakers of the National Assembly, all charged with ensuring that this arm of the state performs its mandate of crafting legislation and holding the executive accountable. To be Speaker of the National Assembly is a role that comes with a great responsibility, one that requires the ability to distinguish between serving the political organization that deployed you as a member of parliament and serving the constitution to which you take an oath once you are elected speaker by a majority in this house. That oath is owed to all 400 members of this house and to the public who elected them, not merely to the party that put you here as a speaker. Unfortunately, over the last 15 years, a culture of prioritizing the party and the elected president over the constitution and oversight has come to characterize those who occupy this office. It began with Ms. Baleka Mbete, who presided over a parliament that received its first scathing rebuke from the Constitutional Court for failing to adhere to the recommendation of the public protector regarding what is now popularly known as the Nkandla scandal. Under Baleka Mbete, the then President of the Republic was shielded through a refusal to allow Parliament to conduct its oversight role through secrecy and through violence, using the deployment of security personnel against unarmed members of Parliament, including women who were violently assaulted for demanding accountability. At that time, we were not quick to act because we believe she could still be reasoned with, but this proved futile. She has since, years later, come forward to confess that she regrets her actions and admits that she did not conduct herself in a manner consistent with her oath of office. That confession changed nothing. The damage had already been done, and it is this country that continues to carry the consequences. Ms. Nosiviwe Mapisa Ngakula followed in her footsteps and was a speaker who carried open disdain for members of parliament who raised the Phala Phala saga in this house, calling us names and equally deploying security personnel to assault us, members who dare raise the matter. It was under Nosiviwe Mapisa Ngakula that this parliament conducted an unconstitutional and illegal vote to suppress the Section 89 independent panel report into Phala Phala, which found that the president may have violated the constitution by bringing foreign currency into this country without following our laws. The report went further. It said that there was prima facie evidence that President Cyril Ramaphosa was subsequently have abused his office and state resources in trying to recover that foreign currency after it was stolen from him. Ms. Nosiviwe Mapisa Ngakula has since appeared on a podcast where she expressed regret for her conduct as a speaker, yet we remain stuck with the consequence of her actions. Chief amongst this is the current secretary to Parliament, who was irregularly appointed under her watch and has since been awarded salary increases that amount to nothing less than the theft of public money. It was her recklessness in suppressing that report that has left us saddled with the very Phala Phala conundrum to this day. Had she simply allowed the matter to be referred to impeachment committee, as the constitution required, would have impeached Mr. Ramaphosa long ago and moved on as a nation. She too regretted her action, but that regret does not undo the harm this country has suffered. Ms. Thoko Didiza, the current speaker, now forms part of this generation of speakers who put president first and the constitution second. Not only has she dragged her feet, but she has actively failed to execute her responsibilities in defense of the oversight duties of Parliament. This 7th Parliament has, under her stewardship, been the most secretive since the dawn of democracy, with the Speaker controlling matters in a clandestine manner. She does not consult and she manipulates political parties in her efforts to protect the president. On occasions, despite her attempts to appear sophisticated about it, she has misled the public. And when we raised our concerns, she deployed Parliament's communication machinery in response, granting multiple interviews that offered multiple conflicting versions of the same story. When President Cyril Ramaphosa filed papers to take the Section 89 independent panel report on review, following the Constitutional Court judgment that Parliament must establish an impeachment committee to test whether President violated his oath of office, the Speaker, as the head of Parliament, did not oppose that application. Similarly, when Mr. Ramaphosa filed an interdict application to stop the impeachment committee from doing its work pending the outcome of his opportunistic review application, the Speaker again decided not to oppose that application. These two instances are a grave abdication of duty because the Speaker, as head of the legislature, is ultimately the custodian of the Section 89 independent panel report and ought to defend Parliament's process from being compromised and halted by the executive through the judiciary. She has failed to do this because she is partisan. All of these partisan decisions can be traced back to the fact that when Parliament voted on whether to establish an impeachment committee, the then Member of Parliament, Thoko Didiza, voted no and was part of those who voted illegally. Now, as a Speaker of the National Assembly, her attitude towards this process remains no, because she does not want the president held accountable. She did not want accountability then, and she does not want accountability now. What makes matters worse is that the Speaker ignored the legal opinion given to her, which said she must oppose the president's review application and instead went on to seek a legal opinion from the law firm of a former ANC official, one that merely affirmed she will accept any outcome of the court process without filing any argument in defense of Parliament and its work. We must also say this plainly. We keep telling the former liberation movement that they are one of party majority rule in Parliament, in provincial legislature, in municipal councils is over, and that they remain in denial because they are refusing to accept this reality. It is precisely this denial that makes the Speaker's conduct look acceptable when it is not. If this 7th Parliament fails to confront this behavior, it risks becoming a permanent feature of Parliament that no longer commands majority and that cannot be accepted. It is for this reason, and in terms of Section 52, subsection 4 of the Constitution of the Republic of South Africa, that the EFF files this motion of no confidence because Ms. Didiza is not fit to preside over a legislature whose role and constitutional responsibility she is not willing to defend. We call on all political parties to appreciate this, that she has exhibited partisanship at a critical moment in our democracy, when we ought to be showing that no one is above the law, and this includes the president, no matter how powerful the political party that deployed him to that office. Ms. Thoko Didiza must go, and she must go now. I thank you, Chairperson.
Since Floyd has left, the quality of debate has dropped. She's going nowhere.
Order, honorable members. I now hand over the presiding to the Honorable Deputy Speaker. The Honorable Ntuli is the next speaker.
Honorable Ntuli, you are next on.
Thank you very much, Honorable Deputy Speaker. Good afternoon to you and good afternoon to all honorable members. Deputy Speaker, the motion of the EFF is calling for the removal of the Speaker of the National Assembly at the very moment when the integrity of this institution is under the sharpest scrutiny it has faced in years. It is our firm view as the African National Congress that this House considers not only this motion for this debate, but its facts, the law, and indeed the implications. Let us first remind ourselves of where we stand in our constitutional history, because this motion cannot be understood outside that particular and important context. Section 89 of the Constitution grants power to the National Assembly to remove a president for a serious violation of the Constitution and the law. Serious misconduct or inability to perform the functions of office is one of the most consequential and the first of its kind in our constitutional democracy. Madam Deputy Speaker, for years it existed almost entirely on paper. The National Assembly had no rules to give practical effect to it, no committee structure to process it, no circuit practice to guide its proceedings. The Concord in Nkandla judgment found that this assembly had failed to hold the then president accountable, and that no rules existed to give effect to Section 89 of our Constitution. That judgment was the beginning of the establishment of what we now know as Section 89 rules. Perhaps, and most importantly, let us set out the facts as they are and not the caricature offered by the EFF in its campaign for the removal of the Speaker. The Speaker's own explanatory affidavit before the Western Cape High Court sets out that record in detail, and let me make a specific references to it. On the 8th of May 2026, the Concord handed down its judgment on the matter between the EFF and the Speaker of the National Assembly. Accordingly, the Speaker acted without any hesitation to ensure that the National Assembly fully complies with the directive and the order of the Apex Court. On the 11th of May 2026, 3 days after the judgment was handed down, the Speaker formally transmitted the panel report to the President of the Republic in writing, informing him in the same letter that the report will also be referred to an impeachment committee as the court had ordered. On the 12th of May 2026, the report was published for the information of all members. On the 13th of May 2026, the Speaker wrote to every political party in this House requesting nominations for members of the impeachment committee with a deadline of the 22nd of May 2026. Accordingly, all political parties met that deadline. On the 25th of May 2026, the committee's 31 members, drawn from 16 parties in proportion to their representation in this House, was appointed and published. And 6 days later, on the 1st of June 2026, the committee held its first meeting and elected its own chairperson. A day later, on the 2nd of June, the Speaker referred the panel report to the committee, formally activating its mandate under Section 89 rules. That is 25 days from the judgment to a fully constituted impeachment committee. No delay tactics, no constitutional abdication or obfuscation. A Speaker moving with urgency as required under Section 237 of our Constitution, demanding all constitutional obligations to be performed diligently and without delay. It was actually the President, not the Speaker, exercising his constitutional right and enshrined in our Constitution, who legally intervened which introduced to the effect the pace, which impacted on the pace and the substance of what the committee can and cannot do. On the day the committee was constituted, the President launched a review application asking for the court to set aside the panel report itself and to invalidate any parliamentary steps taken in pursuant of it. And days later, his attorney also wrote to the Speaker asking that the committee's formal inquiry be stayed pending the review. The Speaker's response, which is on record, on the very same day she received the letter from the President, refused to grant the President's request. In her letter to the President, the Speaker emphasized that committees determine their own working arrangements in terms of Rule 167, subsection F, and that she has no powers to interfere with the work of the committee, as the Constitutional Court itself indicated that once seized with the matter, the committee performs a distinct investigative function and retains control over its own proceedings. That is the record. A Speaker who complied with a binding order within days, who kept the process moving, who, when the President sought to halt the process, she refused and upheld the independence and principles governing the workings of the National Assembly. Why is the EFF and its allies in this House completely indifferent to this objective reality? The record shows that the Speaker would try to keep the Assembly within the four corners of his constitutional obligation. Number one, comply with the court order. Number two, constitute the committee. Number three, refer the report. And then, of course, step back at the committee, step back and let the committee, not the Speaker, personally carry the constitutional obligations forward. This brings me to the heart of the legal complaint underlying this motion, that the Speaker's decision to file a notice to appoint rather than to formally oppose the President's urgent application to halt the committee's work. The EFF in its motion indicates that the decision offends Rule 2026, which requires the Speaker to act fairly and impartially, and that she acted in a partisan manner in violation of her constitutional obligations. Madam Deputy Speaker, in reality, the opposite is actually the truth. Fairness and impartiality do not require the Speaker personally to become a litigant against the President in every matter before the Assembly. They require her to ensure that the correct constitutional actor, in this case, the impeachment committee itself, which is the body properly seized with the Section 89 inquiry, is able to make its case fully and without any interference. That is exactly what happened. The committee opposed the President's interdict application on its own papers and in its own name, as it was entitled and equipped to do so. And that happened without any objection or interference by the Speaker of the National Assembly. The Speaker did not abandon that fight altogether. She supplemented it. She filed an explanatory affidavit to assist the adjudication of the matter before the court, and the steps she had already taken to comply with the Concord judgment and as well as her obligations. The Speaker's own affidavit is very candid about why she states plainly that given that the committee sees with the matter and will itself report back to the National Assembly on the outcome of its processes, it was necessary at that stage to allow the committee the space to deal with the matter in accordance with its own mandate. And she expressly notes in the same breath that the committee had already elected to oppose the President's application. That cannot be construed, even by a stretch of imagination, as the Speaker's abdicating her responsibility and therefore acting in a partisan manner as alleged by the EFF. The Speaker did not contradict the committee's position. It is in the principle the same position aimed at supplementing and complementing the arguments of the committee, because the Speaker's constitutional role in this process is not identical to that of the committee. And it would have been improper for her to pretend otherwise. It must be noted that by law, to abide by the court's ultimate ruling is not to concede the merits. This motion asks us to remove a Speaker, not for defying the Constitutional Court, not for halting an impeachment inquiry, not for shielding a President from accountability, but for choosing a legally different, a procedurally sound way of assisting a court to understand the perspective, complementary roles of the two constitutional actors, both moving towards the same destination, which is the compliance with a binding judgment of our apex court. If we remove a speaker, Madam Speaker, every time a losing party in a legal dispute dislikes how she understands her own constitutional and institutional role, we will have created a precedent far more dangerous than anything alleged in this motion. We would have told every future speaker that their security of tenure depends not on lawful conduct, but on satisfying the loudest voices in the room on any given day, whether rational or irrational. This will plunge this institution, the National Assembly, into chaos and create a constitutional crisis. We cannot allow the EFF strange way of thinking to prevail. It is dangerous, it is unsustainable. This assembly has created the Section 9 committee, which is on powers as defined in the rules 168 of the NA rules, which litigated in its own right, exactly stipulated by Section 23 of Powers and Privileges and Immunities of Parliament and Provincial Legislatures Act. Therefore, Madam Deputy Speaker, I ask this House to firmly reject the motion and the politically gimmicks of the EFF. And the ANC stands on record before the National Assembly and the people of South Africa that we are firmly opposed to this motion, not only because it is against the Speaker, who happens to be a member and a leader of the African National Congress, but because the facts before us and before the people of South Africa confirm that to decide otherwise would be a dereliction of duty on our part as members of the National Assembly, and we will be acting on the basis of wrong information and wrong understanding of what precisely constitutes the task and the responsibility attended to the Speaker of the National Assembly. I do want to conclude, Madam Deputy Speaker, by saying the Speaker of the National Assembly, Honorable Thoko Didiza, enjoys the support of the African National Congress, and I am convinced, as the Chief Whip of the ANC, that she too also enjoys the support of all members who elected her in 2024. Thank you very much, Madam Speaker.
The next speaker is the Honorable Mkhize. Honorable Mkhize.
Honorable Chairperson, siyiqembu lomkhonto weSizwe sisukuma ngokungananazi futhi sifuna ukusho kuzwakale futhi kucace ukuthi siyaseseka isiphakamiso sokungathenjwa kukaSolomo wesishayamthetho sikazwelonke uHonorable Thoko Didiza. Phecelezi, we rise in full support of the motion of no confidence in the Speaker of the National Assembly, Honorable Thoko Didiza, tabled in terms of Section 52, subsection 4 of the Constitution. Lokhu asikwenzi ngoba sizama ukususa uchuku noma ngoba siqhuba ipolitiki yamaqembu. Sikwenza ngoba sikhathazekile siwumkhonto weSizwe ukuthi ngabe lendlu yePhalamende isayisikhungo sikahulumeni esizimele ngempela na, njengoba kubekwe under uSection 42, subsection 3 somthetho sisekelo, noma sesiphenduke nje isandiso seLuthuli House. The office of the Speaker is not ceremonial. The Speaker is the guardian of this House's institutional independence. Ngokuka Section 55, subsection 2 and Section 89 ye-Constitution, eminye yemisebenzi yakhe njengoSpeaker ukuvikela igunya lePhalamende nokuqinisekisa ukuthi uhulumeni ophethe uyaphendula futhi nokuthi uyaziphendulela iningi labantu. Akumeleke lokhu kuthanjiswe noma kuhlehliswe ngoba nakhu kungahambiselani noNomzana uRamaphosa kanye nomshado wakhe awakhe neDA noma neGNU yakhe. Yingakho ke siwumkhonto weSizwe Party sithi uHonorable Thoko Didiza wehlulekile ukusimela njengosomlomo wesishayamthetho sikazwelonke. When the President of the Republic approached the Western Cape High Court to interdict a constitutionally mandated impeachment process flowing directly from a constitutional court order, he made Parliament the respondent. In that moment, there was no neutral ground. The Speaker had two options: to either defend his house or abandon it. Please protect me from the ANC.
Honorable Honourable member, just pause for a moment. Minister
Wait,
Mantashe,
Mantashe, you are
please.
misbehaving.
Honourable members, please mute your microphones. And I'm
Speaker,
speaking
can I also
specifically-
just raise a point of order?
What is your point of order?
Our member was distracted more than 3 times, Speaker, and you did not say anything.
Honourable member,
The
that is my
speaker needs more
discretion. I
time.
am now intervening. Honourable Reddy, you have not been recognised. Do not activate your microphone if you have not been recognised. I am requesting all members to mute their microphones. Minister Mantashe, please mute your microphone. Honourable Mkhize, please proceed. I see there is, right, that hand has been lowered. So Honourable Mkhize, please proceed.
Thank you, House Chair. The Speaker had 2 options: to either defend this House or abandon it. She chose to abandon it as she filed a notice to abide. Abiding is not imperiality, it is abdication. Honourable members, an explanatory affidavit is not opposition. Assisting the court is not defending Parliament. When the executive seeks to freeze Parliament mid-function, a speaker who abides is not being restrained. She is capitulating. Secondly, she rejected her own institutional advice. This was not an error in a vacuum. The Speaker had before her sound, independent legal advice that she herself commissioned, which recommended unequivocally that Parliament must oppose the President's application. She set that advice aside. And in doing so, she instead leaned on counsel from an attorney whose own political history includes serving as former Treasurer General of the African National Congress, the very party of the sitting president who stood as an applicant. We make no aspersions on that individual's personal integrity, but for a speaker whose legitimacy depends entirely on the perception and reality of independence, the optics are constitutionally intolerable. She sought comfort from the ANC-aligned council rather than from the institutional advice that told her plainly, defend this House. The House defended itself despite having a speaker. What makes this indefensible is that this House's own Section 89 impeachment committee understood what the Speaker did not understand. By an overwhelming majority, that committee, chaired by Honourable Ghana, resolved to oppose the President's interdict application, guided by the same core principles the Speaker's own advisers had identified. A process mandated by the Constitutional Court cannot be suspended at the instance of the very person whose fitness to hold office is under investigation. The committee therefore acted to protect Parliament, but the Speaker did not. We now have the untenable position where a committee of this House must defend Parliament against the executive, while the Speaker of this House refuses to. This is a pattern, not an incident. Honourable Chairperson, we have seen this instinct before. In December 2022, the House voted to block any Phala Phala inquiry altogether, a decision the Constitutional Court later declared unlawful and irrational. That unlawful shielding was overturned by the courts. What we are witnessing now is the same shielding instinct reasserting itself through quieter means, not an outright vote to block accountability, but a presiding officer's refusal to stand up for the institution that she leads. Selokhu kwaqala lolu daba lePhala Phala, uMkhonto weSizwe Party simi nje ephuzwini elilodwa lokuthi akekho umuntu ongaphezulu komthetho kulabo abaphethe izikhundla zombuso, sisho naye uSpeaker kanye nomongameli wakhe uMnumzana uRamaphosa. No office bearer is above scrutiny under Section 89, and no speaker may use neutrality as a license to protect the executive from the consequences of its own conduct. Umuntu akavuni akutshalile. We have heard the defenses offered that the Speaker complied with the Constitutional Court directive and that criticism is a false narrative. That filing an explanatory affidavit is sufficient. That the IFP and the ANC believe that the threshold for removal has not been met. We reject that defense in its entirety. Compliance with the order to establish the committee does not license abandonment of the committee when it comes under legal attack. Discretion exercised in favor for the executive at the direct expense of Parliament's institutional standing is not discretion, it is dereliction. And when the Speaker forfeits her ability to be seen as an independent, she forfeits the confidence of this House to preside over it. Honorable Chairperson, for these reasons, the uMkhonto weSizwe Party will vote yes in support of this motion of no confidence. We do so not out of hostility to Honorable Didiza as a person, but out of fidelity to a foundational constitutional principle. The Speaker of this House must answer to Parliament and to Parliament alone. A Speaker who will not defend Parliament against the presidency cannot preside over Parliament. Fa Speaker a sa kgone go sireletsa seriti le boikemelo ba Parlamente kgatlhanong le kantoro ya mopresidente ga a tshwanela go etela Parlamente pele. Sengiqedile ngizovala ngelithi sukuma mntomusha uzilwele ngevoti lakho. It's time for young people to occupy their space by voting for the party on the 4th of November. Gwaza and staff, I thank you. Gwaza uMkhonto.
New members of the Honorable members of the MK, please mute your microphones. We now proceed. The Honorable Breitenbach. I see there is a hand raised. Before you proceed, Honorable Breitenbach, Honorable Maduna, what is your point of order?
No, thank you, Speaker. I want to call a point of order.
Please proceed.
I think yes, I want to call a point of order. It's for the second time now, the honorable members from MKP making such noise, and you have not told them.
Suga.
Please, can you?
Honorable
Mr.
member.
Galanis' son is not going.
Awuhlale phansi Maduna, hlala phansi, hlala phansi.
Honorable members.
Bengibangumsindo nina la sithulile, benibangumsindo umani
Honorable Shongwe,
Go to school.
mute your microphone. You have not been recognized.
I didn't say anything, Chair.
Honorable Shongwe, but you were unmuted. All members,
Never,
please
Chair.
mute your microphones. If I name you 3 times, you will be removed from the platform. Honorable Reddy, what is your point of order?
Honorable Deputy Speaker, that point of order is out of order because you're supposed to raise the point when the transgression apparently occurred. The member chooses to raise it after. That is out of order.
Honorable Reddy, the honorable member could not raise the point before I recognize him to raise the point, and it was such an absolute mess and noise with the MK members all unmuting that I could not recognize him. So please, the members, control yourselves. Chief Whips, please exercise discipline. We are working on a virtual platform, and it is extremely difficult to hear everyone because I cannot see all of you. So Honorable Shongwe, Honorable Mutaung, the matter has now been closed. I have now ruled. Do you have a new matter that I will recognize? Honorable Mutaung.